Introducing Lana Clark, Attorney at Law, Certified Specialist in Estate Planning, Trust, and Probate Law, California State Bar, Board of Legal Specialization.
Different types of healthcare directives. Probably the most common one that you may hear of is one put out by the California Medical Association. It's kind of a form that you fill in the blanks, and it says who do you want as your agent, what type of treatment do you want to decline, and so you check the boxes, fill it in, and sign it. Doctors and hospitals are familiar with that form because they see it a lot, so there's the advantage of having that form when the doctors already know about that form. There's also a form that Cottage Hospital gives out, and it's one called 5 Wishes, and it's very unique. A lot of people like it, other people do not like it, so that's a different form. And in the handout that I have, there's actually the website listed where it's on page 4, where you can go look at it, and you can actually purchase it for only a cost of $5, kind of toward the bottom of page 4 of the handout, just above the conclusion. And this 5 Wishes form kind of has a lot of questions where you can designate how you want your body to be treated if you are in a coma. You finding it? It's one that's, yeah, page 4 of this one. Okay, so
Aging with Dignity.
yes, Aging with Dignity is the company that puts it out. You can look at it on their website. Now, the thing that makes the 5 Wishes Healthcare Directive a little different is it tells even more than just who's the agent that's going to make decisions for you. It has a place where you can check the things that you like. If I'm in a coma, I want my body rubbed with oil. I want soft music played in the room where I am. And if you're in a coma, all of these things may be something you would like to have. Some people say, well, if I'm in a coma, I don't care. Who knows? But some people believe that there's still maybe a subconscious that may have some sense of understanding even while you're in a coma. If those things are important to you about music and how your body is treated, you may really like the 5 Wishes. So it's something to look at and compare. And of course it also says that I give permission to terminate life support if that's needed. So that's a form that you have as an option to sign. There's also a customized form that I do as an attorney that's much more, it's kind of much more detailed, and it provides not only decisions about medical, but it designates whether you want to be an organ donor, and if you want burial instructions, certain types of things that you want done. So it's a little bit more comprehensive. It's a little longer document, but it's something that can be customized to your desires. So there's 3 different types of healthcare directives. You have to decide what's the one that you feel most comfortable with. A fill in the box, a more comprehensive one about how I want my body to be treated while I'm unable to do that, make those decisions for myself, or a comprehensive one that may be more suited to what you want to do. So those are things you can talk with an attorney about. You can make the decisions on your own, but the important thing is for it to be valid, it has to be properly signed. And that means notarized or signed by 2 people as a witness. And if a person who's signing a healthcare directive is in a nursing home, it also has to be signed by the ombudsman who's in that nursing home facility to make sure that somebody is not exerting undue influence over them to get them to agree to sign documents.
That's what I was going to ask. Is all of these documents have to be notarized? And,
yes, either notarized or witnessed by 2 people.
Yeah.
And if the person's in a nursing home,
So
it has to be witnessed by 2 people and an ombudsman.
Yeah. Okay.
Every nursing home has someone designated to be the ombudsman to make sure that somebody isn't slipping in and convincing people to sign documents without them really understanding it. So that's important. Okay, so now let's talk for a minute about power of attorney documents. And you can feel free to continue to ask questions as we go along. So the really in the very first page of this handout, it kind of has an interesting scenario that kind of, says, you receive a phone call from a doctor or hospital official saying your mother's been hospitalized after a fall, and the initial evaluation is that she needs a hip replacement surgery. You're the nearest child who's been helping with care for your mother, and her mental abilities have deteriorated. So, what are your options to solve the dilemma? So we've talked about conservatorships. We've talked about healthcare directives to prevent a conservatorship. So now the next step is to say, what can I do to avoid a conservatorship, to name somebody to manage my finances for me in case I am temporarily or permanently disabled or incapacitated where I can't manage my own finances. So that document is a power of attorney document, which is explained starting on page 2 and 3 of the handout that I've given you. So now a power of attorney has different types of power of attorneys. And so if you're going out of town on an extended vacation, but you have this escrow that is already in the works, and you're not going to be around to sign the closing documents, you can have a special power of attorney that's limited only for the purpose of designating someone who has the ability to sign documents for you. And it terminates at a certain time after the escrow closes, and those are very effective short-term, limited-use special power of attorneys. Those people don't do those very often because those types of situations don't come up except occasionally. But nonetheless, that is one type of power of attorney. The most common types of power of attorney is a durable power of attorney. And this one, you fill it out now to designate the person you want to manage your finances. And usually it's your partner or your spouse. And then you name someone as an alternate and maybe even a second alternate in case the first person isn't able to do it. Or if you're in a common car accident with your husband and your child that are both your agents, now who's going to do it? You have to have another alternate. So it's really good to have the first person you name and at least one alternate, but maybe two, just in case you're all together in some family outing and some really catastrophic accident occurs, which is kind of the reason why a lot of people who have great amounts of wealth that they have concern about, they never all fly on the same plane. Because if your whole family is going to a place for a family reunion and the plane goes down, now everybody is out of the picture. So they fly on different planes, and it's just an extra precaution. And it doesn't happen very often, but when it does happen, it's pretty devastating for a family to have a whole family that's wiped out in one time. Okay, so the durable power of attorney is a document that is still effective once you become incapacitated. So if you develop Alzheimer's or dementia, this power of attorney is durable. It doesn't stop. It's lasting for the remainder of your lifetime. Many years ago, decades ago, power of attorneys used to have a limit where they would only be good for 7 years. Now they're good for the rest of your lifetime. You can change them if you want to change your agent, but you have to take some steps to make sure you void the old one. And if that power of attorney has been given to any banks or investment advisors, you have to let them know that you're canceling it and let them know who the next agent is. Because once a person has been named as your agent under a power of attorney, that person, when they get a doctor that certifies that you're incapacitated, can take that power of attorney to the bank, be added to your checking account, and can start writing checks, liquidating your assets, and basically spending your money. Now, they're restricted where they can only use it for your benefit, but I've seen instances where a son will get the power and go dip into mom's account, and next thing you know, $10,000 has been taken out. So what's mom going to do? Technically, she can sue her son to have him return the money, but a lot of times parents go, oh, well, that's just Johnny. He needed the money, and so, the money goes off. But there can be some criminal issues, elder abuse issues. If the person you're naming goes beyond their authority to manage your money, and if they even invest your money in very frivolous or high-risk investments and they cause a lot of money to be lost, they can be personally liable. But collecting it involves filing a lawsuit against them, and that's lengthy and expensive. So a lot of people just kind of shrug it off and say, oh, well, my agent has taken more money than what they should, but they just kind of blow it away. Sometimes when it's many tens of thousands or hundreds of thousands of dollars, then it becomes a more serious issue. The district attorney's office will look into elder abuse charges and decide whether they're going to file criminal charges, or you file civil lawsuits to get them to return the money. All of those things are expensive. So how do you avoid that? You have to be real careful in the person you choose to manage your finances for you. Can you trust your own children or your friend or relatives? That's a personal question that only you can answer. Certainly if you have children that are involved in illegal activities or drug abuse, they would not be good choices to manage your finances for you, because the money might be more likely to be taken away and used for improper purposes. So now, your power of attorney you can state that it's effective immediately, and this is appropriate for elderly people who want to bring in a child to say, I want my daughter to start acting immediately as my agent. So that power of attorney can state that I give this power immediately to my daughter or my son or whomever you're naming, and that person can then start signing on checks or managing financial investments for you if you feel you're ready for that person to do it right away. Most power of attorneys have a springing condition, so it doesn't take effect until a doctor signs some sort of a certification that you're incapacitated. That's kind of a protection to you, because it prevents somebody from stepping in and doing it sooner than what you want them to do. So as long as you're able to manage your finances, you can keep doing it. But once you get into that position where you're not able to do it on your own, then the doctor can certify that, and you then have someone step in and help. So whether it requires one doctor or two doctors is different in different types of power of attorney forms. You can get forms for them. You go online and do searches. You can find a lot of forms. Whether they're appropriate for California is the question. Whether they're appropriate for your circumstance is questionable. So doing a lot of self-help, it may be fine, it may not. And unfortunately, you don't know if your document has got defects or is faulty or isn't follow California law until you get to the point where you need to use it. And then if you find out if it's defective in some way, then you've got more problems to deal with. So generally you go to an attorney when you're having an estate plan done. You have a will done, power of attorney, a healthcare directive. If you have more than $150,000 worth of combined assets, then you're going to have a probate at the time you pass away. So in order to avoid the probate, you can create a living trust. And certainly if you have a house, you want to have a living trust to designate where it's going to go. You can own a house or a bank account jointly with someone else in joint tenancy. When you pass away, it goes to the other person. But then when that other person passes, that house has to go through probate unless you have created a trust, changed the title to the house into the trust. So there's some things about having a trust that avoids probate, which is kind of a different subject than power of attorneys and healthcare directives. But frequently when you go to an attorney to have an estate plan done, you're having all these documents done at once. You kind of say, let's get everything in order. So you have a trust, a will, power of attorney, healthcare directive, a final disposition document to say whether you want to be cremated or buried, and if you've purchased policies for that to be done, changing title to your property into the trust. So all of those are done all at one time when you're having an estate plan done.